立法會主席。
我哋繼續處理道歉條例草案，有冇議員想發言？陳禮謙議員。
Morning, Mr. President. We are talking about the apology bill that we are about to enact that into law. I must confess that I know very little about this apology bill because I have not engaged in the study of this particular bill as a member of the Bills Committee. But spending hours listening to my colleagues' speeches and wisdom, I must confess that it confused me a little, in fact, more than a little, when they talk about this apology bill, which is common in Canada, Australia, England, and UK, that apologies could be made but without legal liability. It is a form of dispute resolution that prevents litigation from going through the courts, saving courts time and money to arrive at a settlement. While with all the good intention, it is somehow misleading because the reason is different from the Western countries, that when they say something, they don't mean it. In our Chinese culture, even when we were small, we were taught to, when we say sorry, we should be remorseful of what we said. Saying sorry without the meaning, without the feeling of remorseness, saying sorry without the meaning of sorrow, or even saying sorry without the feeling of sympathy. This is un-Chinese and un-Asian. To say apologies without the meaning of apology, acknowledgement of guilt without acknowledgement. And all this is so different to our culture, to our society's belief. What are we teaching our children? I've been a legislator for about 18 years. When we pass laws, the laws must be clear without any ambiguity. But now we are passing a law which asks us to have different meaning of sorry, apologies, acknowledgement of wrongdoing without any meaning of that feeling, just to seek a settlement. This is something very different to our culture. Just because they practice in states which people are different to us. When I was trying to get some understanding, then I was reading a piece of Đạo Đức Kinh, and it says that you do not see, but the way is there. That's the invisible way. That I can understand is a philosophy, or it could be a religion, that the good will be rewarded, the bad will be punished. When someone tells someone that, I'm sorry, I'm wrong, but I do not have any responsibility, this is something that cannot be accepted. So, Mr. President, I find it very difficult to be part of this council to enact a law that have so many ambiguous meaning and so have so many hidden understanding of what the words apologies, sorry mean. That, Mr. President, I'm not going to vote on this bill.
有冇其他議員想發言？如果冇嘅，我現在就請政司司長答辯，之後辯論即告結束。司長。
President, first of all, I would like to express our gratitude to the Honourable Holden Chow, the Chairman of the Bills Committee of the Apology Bill, and all the members of the Bills Committee for their contribution in respect of the scrutiny of the bill. In this regard, I would also like to thank the staff of the Legislative Council who provided unfailing support to the Bills Committee for working within a tight timetable and thus make it possible to resume the second reading of the bill within this legislative session. Needless to say, I am also grateful to the deputations and individuals for the constructive wills they put forward in relation to the bill. As I pointed out when I introduced the bill into this Council in February this year, the objective of the bill is to facilitate the resolution of disputes by promoting and encouraging the making of apologies by parties in disputes when they want to do so by stating the legal consequence of making an apology. Such disputes include disputes arising from medical negligence and healthcare cases mentioned by a member at yesterday's debate. The bill was formulated on the basis of the recommendations made by the Steering Committee on Mediation after 2 rounds of public consultation held in 2015 and 2016. We also provided briefings to the panel on administration of justice and legal services in 2015 and 2016. I shall move to committee stage amendments at a later stage. The CSAs, which have all been endorsed by the Bills Committee, can be outlined as follows. Clause 4 of the bill defines an apology as an expression of a person's regret, sympathy, or benevolence. If part of that expression is an admission of the person's fault or liability, or a statement of fact, the admission or statement is also included in the meaning of apology. Under Clause 8, Bracket 1 of the bill, evidence of an apology, including an accompanying statement of fact made by a person in connection with a matter, is not admissible in applicable proceedings as evidence for determining fault, liability, or any other issue in connection with the matter to the prejudice of the person. Nevertheless, under the original proposed Clause 8, Bracket 2 of the bill, the decision maker of the relevant applicable proceedings may exercise a discretion to admit a statement of fact contained in an apology as evidence in the relevant proceedings if there is an exceptional case and the decision maker is satisfied that it is just and equitable to do so, having regard to all the relevant circumstances. An example of such an exceptional case is given in Clause 8, Bracket 2, which is where there is no other evidence available for determining an issue. Some members consider that the discretions of the decision maker, and in particular the words "all the relevant circumstances" in Clause 8, Bracket 2, would give rise to uncertainties. Some members took the view that this might deter people from disclosing statements of fact when making apologies. We understand those views expressed by members. As a matter of fact, the issues involved were studied in depth by the Department of Justice and discussed thoroughly by the Bills Committee. Having carefully considered the views expressed by the members of the Bills Committee, and without unduly restricting the discretions of the decision maker as defined in the bill, we decided to propose CSA to Clause 8, Bracket 2. The effect of the CSA is that if there is an exceptional case in the relevant particular proceedings, the decision maker has to give regard to the public interest or the interests of the administrations of justice in deciding whether it is just and equitable to exercise the discretion. We share the views of some members of the Bills Committee that a decision maker would necessarily take into account and consider all relevant circumstances in deciding whether it is just and equitable to exercise discretion, having regard to the public interest and the interests of the administration of justice. The CSA in question is also in response to the views of some members on the need for clearer guidelines for the exercise of the discretions. We take the view that the above proposal will strike an appropriate balance between achieving the policy objective of the bill on the one hand and safeguarding the interests of the potential claimants on the other. While the objective of the bill is to encourage the making of sincere and meaningful apologies, that include statements of fact. This should not be achieved at the expense of the parties' fundamental rights to a fair hearing and to secure a just resolution of disputes in accordance with their substantive rights. If we were to remove the discretions altogether, there is a real risk that the provision might become unconstitutional and might in turn give rise to all sorts of uncertainties. In the course of yesterday's debate, I note that Dr. Honourable Yu Chongyim suggested that there is an inconsistency between the English version and the Chinese version of Clause H, bracket 2, regarding the use of the expression just and equitable. We have looked at the position and do not think that there is any inconsistency. The Chinese expression, and I quote, 公正及公平, end of quote, which can be found in the Chinese version of the bill, has been used as the Chinese equivalent of just and equitable in many of the local legislation. I also note that Honourable Claudia Mo expressed concern about the position of the decision maker. As defined in Clause H, bracket 4 of the bill, the expression decision maker is defined to mean the person, whether a court, a tribunal, an arbitrator, or any other body or individual, having the authority to hear, receive, and examine evidence in the proceedings. Accordingly, the expression decision maker does not mean just any person. Instead, decision maker is the person who has the conduct of the applicable proceedings as defined in Clause 6 of the bill, and who has the jurisdiction to decide on the questions of evidence. Clause 6, bracket 1 sets out the proceedings to which the bill is applicable. Clause 6, bracket 2 provides that applicable proceedings do not include criminal proceedings or proceedings specified in the schedule to the bill. When the bill was being considered, a question was raised as to whether the bill would apply to the proceedings of the Legislative Council. Having regard to the constitutional role and functions of the Legislative Council, we do not intend to apply the bill to the proceedings of the Legislative Council. To avoid any unnecessary doubt, we decide to propose CSA to expressly disapply the Apology Bill to proceedings of the Legislative Council, including proceedings of its committees, panels, or subcommittees. The bill is the latest initiative for implementing the government's policy to encourage the wider use of mediation in resolving disputes. Experiences and studies in other jurisdictions demonstrate that apology legislation would facilitate settlement of disputes and would thereby reduce hostile litigation. If and when enacted, the Hong Kong Special Administrative Region will be the first jurisdiction in Asia to have apology legislation and the first jurisdiction amongst the 56 common law jurisdictions that we have studied to protect statements of fact in an apology legislation. This, we believe, will help further enhance the Hong Kong SAR's position as a centre for international legal and dispute resolution services in the Asia-Pacific region, and hopefully will also bring about a change in the dispute resolution culture. With these remarks, I urge members to support the passage of the second reading of the bill and the amendments that I will move at the subsequent committee stage. Thank you, President.
現在嘅待決議題係道歉條例草案，予以二讀。贊成嘅請舉手。反對。姚松炎議員要求記名點票，點會鐘響5分鐘。 表決開始。請核對所作嘅表決。如果冇問題嘅，現在停止表決，顯示結果。出席35位，贊成33位，係1位反對嘅。議題係獲得在席議員以過半數贊成，我宣布議案獲得通過。
道歉條例草案。
本會現在成為全體委員會，就條例草案嘅辯論同埋